Is the Trump administration openly defying yet another judge's orders? This time, Judge Alsup, senior status judge in San Francisco, who ordered the return, as of Monday, of more than 25,000 probationary workers, those that worked for the government a year or less, which the judge found to be the lifeblood of civil service and service being provided to the American people. They were supposed to have done it, but press reports indicate that the Trump administration was returning them, but not to their jobs, but only to paid leave. And that pissed off the judge, who issued a request for information, a quite unusual device for a judge to issue. I'll tell you what happened next, and an overlapping case in Maryland right here on Legal AF. Lots of action in the last 24 hours. I just did a Popok live podcast last night for the Midas Touch YouTube channel. I covered 5 different orders, all came down on the same day. And this one in particular, I want to drill down on. Now, you may remember that Judge Alsup in San Francisco basically called the Trump administration a liar during a hearing about 10 days ago. Back-to-back orders, one in Maryland with Judge Bredar, one in San Francisco with Judge Alsup, ordered DOJ to stop firing probationary workers and ordered the government and overlapping agencies and departments of the government to rehire and reinstate, and gave them about 2 weeks to do so. The suit in front of Judge Alsup was brought by the American Federation of Government Employees, AFGE, and the AFL-CIO, 2 very large labor unions representing federal workers. The judge said, "I don't believe you, government, when you stand here and tell me," and he said, "it's a sad day in my courtroom in America where the government tells me a lie, that they fired government workers for performance reasons when there wasn't any performance evaluation whatsoever. They were fired for cost cutting and because they were just seen as a number and not as a paycheck or an American citizen, and they were just terminated." And the judge ordered them to be reinstated. Now, Judge Bredar did the same thing in Maryland, but under different principles. He used the principle that there's a congressional law regarding reductions in force by the government and a warning. It's a warn notice that has to go out, that didn't go out, and didn't give states time to prepare for these swelling, ballooning unemployment lines. But let's back to Alsup for a minute. Alsup reads government media reports that indicate that, yes, some of the people are being returned to their jobs, but being put immediately on paid administrative leave. So he issued a very unusual communique from himself to the lawyers. He could have done it by order to show cause. He did it by a request for information. He said the court has read reports that in at least one agency, probationary employees are being rehired, but then placed on administrative leave en masse. This is not allowed by the preliminary injunction that he entered, for it would not restore the services the preliminary injunction intends to restore. Defendant shall state the extent to which any rehired probationary employees are being placed on administrative leave by yesterday at noon. All right, now we're off and running. Now remember, there's overlapping things here. In the Bredar case, the government filed a very lengthy status report claiming to have rehired in some capacity 26,000 people pursuant to that order. So Trump tried to get away with a little fast and loose here by telling Judge Alsup in their response to his request for information, his RFI, that, well, we just filed a status report before Judge Bredar about the rehiring of lots of people, and we're not trying to skirt your order, but they are. We're just trying to slow walk it. We need to put them on probation and paid so we can get all the administrative and logistical things squared away, like their name badges and get their computers turned on and get them set up in payroll, all that stuff, Judge. So it's really just temporary interim, but we're not going to tell you which agencies are actually doing that and which agencies aren't doing that. We're just going to tell you that in general, that's how we're using probationary leave, although we're not going to tell you the specifics about any of the individual 25,000, but we're just going to tell you in general. Is that good? That's sort of my rambling response here that they gave in their third request for information. I'll just give you an example. notice in response to the third request for information, as they say on page 1, as highlighted in agency declarations attached in that status report in Maryland, Judge, administrative leave is not being used to skirt the requirement of reinstatement, but it's merely a first part of a series of steps to reinstate probationary employees. For example, a declaration submitted by an official from the U.S. Department of Energy states, and they just give one example. I mean, there's 7 different agencies. They just go, oh, the Energy Department's doing it this way. They've been placed on retroactive leave until their badging and IT access are restored. Okay. But there's 7 different agencies that the injunction was supposed to apply to. So where's the rest of the information? They end it this way. Defendants, which is the Trump administration, understand that without this context, the court may have questions about whether the placement of employees on administrative leave was an effort to avoid the injunction, but hope this clarification explains it. Well, not really, because then the judge fires back. Then the judge fires back with a supplement and said the Department of Defense, an enjoined relief defendant here, is not a restrained defendant in Maryland. And defendant's reproduction of the Maryland declarations is silent as the Department of Defense. So you shall redress that deficiency by today at noon. And if there's a response, the plaintiffs can respond by the 20th. It is so ordered. What are we watching? We're watching another method that federal judges have to try to stop abuse of the court system. And this is a preliminary step among many, a progressive step in order that could end with contempt of court, finding that the department or the government has willfully violated a federal court order. He could issue a contempt proceeding, have a contempt proceeding, an evidentiary hearing, and then he could issue a contempt sanction. Could be fines, could be lots of fines, lots of money, or it could be jail, or both. And if he can't get a federal marshal to put people in jail because Pam Bondi, the attorney general, tells them not to, then Judge Alsup can consider, as all federal judges can, deputizing other law enforcement. He's in California. There's plenty of democratically controlled law enforcement in California, including at the governor level. So maybe the National Guard goes and picks up somebody in Washington. I mean, this is where we're at, folks. Now, one interesting point I'll make on this hot take. There is an open defiance of the Trump administration of federal judges. You've seen it. We talked about it at length even yesterday. Attacks on the federal judiciary, attacks on the rule of law, attacks on the ability of a single judge to issue a remedy like an injunction nationwide, attacks on the sanctity of judges per se, calling them corrupt, calling them depraved, calling them criminals, saying they don't have the right to block a president, which they do in case of constitutional or statutory violation. So they're openly defying judges like Judge Boasberg and other judges. They're not defying every court order. As you see, they just filed a lengthy status report in Maryland, which told the other judge in this type of case, Judge Bredar, that they've rehired 25,000. So they're picking their moments on what they want to challenge to take to the United States Supreme Court. Immigration, use of the Alien Enemies Act, they're going to try it. They're going to try to defy Judge Boasberg. And, that's what got Chief Justice John Roberts all in a lather. And he fired out his own communique to the Trump administration and Trump himself and told him to knock it off. Stop talking about impeachment. You got a problem with a trial judge, you appeal it. And with a very unusual, probably first time in 50 years I've seen a federal judge or a Supreme Court judge issue a public statement against the President of the United States. But those are the times that we're in. I'll continue to follow what's going on in the Alsup case as this moves inevitably towards a contempt proceeding. We'll see how the Department of Defense responds today, and I'll follow up on that right here on Legal AF. So until my next report, I'm Michael Popok. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.